Good morning, good afternoon, good evening to all of you, depending on where you are. So today we are going to speak about initial meeting and pre-mediation phase. I would be glad to share with you my views based on my experience. So let me share my screen. Before we start, I know that there are some of you who already have mediation experience and there are beginners. What do you think? Are they the same, initial meeting and pre-mediation? You can write in the chat, you can raise your hand and turn on your mic and answer. Very provocative beginning. Any views? So why? Yes, somebody wants to answer something in the chat. Sorry, your connection is not good and you're not audible. Maybe you could write in the chat. We have an answer from Jerry. Not the same. Okay. Maybe no. Plan is prayer and initial is first time meeting. Right, Carol, thank you. So Anuji want to answer my question. Anuji, you are welcome.
Hello, Vedana. Yes, I think it's two different things because initial meeting is when you first decide to have a meeting with all the parties, and the pre-mediation session, I think it's more of you having individual meetings separately with the parties to discuss about roughly what the situation and what the dispute that have happened between them, and whatever the things they need to, maybe confidential information a little bit, to share with the mediator and the parties between them.
Thank you. Thank you for even details. Thank you, Anuja. So this topic is interesting to myself in terms of the mediation session itself, quality and its flow. So further mediation session, which usually follows initial meeting and pre-mediation. So today it's a very short webinar, but we're going to cover differences and similarities of these two phases. We will also look into the objectives and deliverables and time frame of these two phases. And of course, at the end of our session, you're welcome with your questions. Before we get deep into these two phases, let's refresh mediation structure. It is less formal, but still formal process. Don't forget about it. There are different views. Some say that it's not formal at all. Some say that it's less formal. I prefer to consider mediation process less formal than, for example, litigation or arbitration, but still formal. Because if it is formal, there is structure. It helps you to avoid chaos. It helps you to form more serious attitude of the parties and their lawyers to the process. So it is less formal and it is quite structured process. As for mediation session itself, it has several sub-phases, namely mediator introduction, opening remarks or opening statements, joint discussions, private caucuses, and negotiation or bargaining phase. And during the closure phase, there is finalizing draft agreement, then party sign the settlement agreement if they agreed, and enforcement if there is need to enforce the agreement. But what happens before mediation? There is initial meeting and pre-mediation phase. So when I had my first mediation training, and it was more than 9 years ago, we were explained that there is initial meeting that happens before mediation and there is mediation session. And when I started my practice, frankly speaking, from the very beginning, I feel the gap between mediation session itself and initial meeting. And I could not define the exact time frame of the initial meeting. So sometimes it was too short, sometimes it was too long. And I even did not focus much on the initial meeting. I was mostly focused on mediation session. But initial meeting and pre-mediation phase, these are very important phases which influence mediation session a lot. So there are some similarities between these two phases. That's why some people mix them. Some consider these two phases as the same because there are some similarities. And what are these similarities? Two phases take place before mediation session. They give more understanding about the issue and parties involved. They help parties to feel more comfortable with the following mediation session. And of course, they contribute to the efficiency of a mediation session if they are conducted professionally. But there are differences. We have two hands. So
yes, I just wanted to interrupt you to say that I personally see the first slide of the presentation. So just letting you know about this.
Really?
Yeah.
So let me share my screen once more. What about others?
I'm also seeing just the first the first slide.
The first slide. Okay.
Yeah, the same. Yeah.
It's fixed now, thank you.
Is it okay now?
Yes,
Yes.
we can see the third slide, phases
Yes.
of the mediation
Yes.
process.
Here is the third one about similarities. So then differences. So we had two questions or comments in the chat. Just let me. Okay. It was about the screen. Thank you, Yana. And I felt this gap between the initial meeting and mediation session itself. So as I have mentioned, sometimes it was too long, sometimes it was too short. And sometimes unexpectedly for myself, initial meeting developed into mediation session itself without signing the agreement to mediate, and it was not right. But it was experience. So I will share a bit later one of my experiences, one of the examples. What are the differences? Initial meeting happens before the agreement to mediate is concluded. So before to sign the agreement to mediate, you need to conduct the initial meeting. It can happen in different ways. For example, in my country, very often one of the parties apply for mediation. Then this party asks us as mediation provider to invite the other party to the initial meeting. Sometimes, if the relationships are okay and parties can communicate with each other, we ask this party, requesting party, to ask the other party to come to the initial meeting, and it also works. But it happens rarely. Usually we invite. And the invitation can also be different. As for the mediation services within the Center for Mediation and Negotiation, which I am founder of and mediator also, usually we email the other party, we send an email with invitation and attached application form filled in by requesting for the International Court of Arbitration. So when we invite the other parties through this court, usually we send invitation letter through the post office, and because the procedure is more formal, and usually it takes about 10 days to get an answer. Most of the parties, more than 90%, they rarely refuse from the initial meeting because it is not binding. It does not impose any obligations on the parties. It is a meeting where parties express their view on the matter and their positions, but very generally. So as for initial meeting, you present to the parties and their lawyers, if there are lawyers, general information about mediation process, its principles, rules, provisions, if there are some, and you are a mediator for the institution and you will provide mediation services on behalf of the institution. Parties provide you general information about the matter and about their views on the matter. During initial meeting, you need to identify the relevance of mediation application to understand whether mediation is applicable for this particular case. And usually the time frame is very important, not to develop it into the mediation session. Usually it takes about 30-40 minutes. If it is a joint meeting, joint initial meeting, and if these are two separate meetings with each party separately, then there are two meetings, 30-40 minutes each. As for pre-mediation, it happens after agreement to mediate is signed. It's really helpful in terms of strategizing, in terms of designing the process. You help, first of all, you understand more about the matter. You also learn more about parties' personalities, their potential behavior in the mediation process, and you help them to form negotiation strategies which will be used in mediation session. You continue to build rapport because during initial meeting, which usually lasts for 30-40 minutes, it's not possible to build rapport because you need to build rapport with parties and you need to build rapport between them, at least to have some level of trust between them. And usually, as for pre-mediation, of course, it depends on the complexity of the case, but usually these are 2-3 pre-caucuses with each of the parties. I prefer to conduct pre-mediation separately in caucuses because it helps me understand more about the parties and they share more about their vision of the matter, about their possible strategies, about their possible options, etc., if they are discussed. One of my favorite topics in mediation is asking questions. And usually preparing to each stage, I prepare the list of questions to be asked parties during mediation, or during initial session, or during pre-mediation phase. And as for the initial meeting, I suggest you to address 3 main questions. What is the matter about? Who are the parties? And is there room for mediation? These are 3 main questions. As for pre-mediation phase, there are also 3 main questions. Who will participate in mediation? Because if you identified who are the parties during initial meeting, it does not mean that the parties will participate in mediation. Maybe they will be represented by the managers or by lawyers. Of course, most of the parties, especially in commercial mediation, they are represented by their lawyers and they present themselves, but not always. So you need to understand who will be present during mediation session. What points should be addressed in mediation? This is another question. So the second questions, and if you address these second questions, it helps you to analyze possible items for the agenda, which you will discuss with parties during mediation session itself. And how to address them by saying this, by asking the third question, I mean, what questions you can ask during mediation session to address those items, those potential items that you identified with parties during pre-mediation phase. What will be the time for addressing those items? I mean, sequence of the items to discuss, because there is so I'm sharing one of my secrets, mediation secrets, which I usually use when you frame the agenda. Usually there are several questions, not one question, at least 2 or 3 or 4 sometimes. And depending on the complexity of questions, there are some questions that would be easier for parties to agree on. And if I may, I suggest them to start from the question that are easier to agree on. And this helps them to build rapport between each other, between them, and also to potentially agree on the other issues which are more complex. So what are the main objectives of the initial meeting? The main objective of the initial meeting is to identify whether mediation is applicable in this particular case and to encourage parties to mediate. I don't like word to convince parties to mediate, because if you are trying to convince, it looks and sounds like artificial. To be more authentic, you need to just simply, in a simple language, to explain parties what mediation is, what to expect from this process, what are the principles, what are responsibilities of each participant in mediation process. And by this, you are encouraging them to mediate, because I think when you present the reality and it looks and sounds authentically, it more involving and welcoming parties to jump in mediation. And the main deliverable of the initial meeting is an agreement to mediate. I have no doubt that almost all mediators have samples of different documents that are used in mediation, including agreement to mediate. So if parties after initial meeting are ready to mediate and they are ready to sign this agreement, so please do it the same day. Or usually it happens 2 or 3 days later, but not later than 2 or 3 days. And as for pre-mediation, pre-mediation is the essential link between the initial meeting and mediation session. And its importance should not be underestimated. It's like a bridge between initial meeting and between mediation itself. So the first time when I saw how pre-mediation happens, this was time of my fellowship in the US, when I had an opportunity to shadow mediations of very well-known, distinguished, and highly demanded mediators. And just, it was amazing when parties with the mediator were preparing to the mediation session, and then mediation session was much more comfortable and easy for them to participate in. So pre-mediation is essential. It helps you to know and understand more about the case. I mean, you as a mediator. It helps you to continue to build rapport and this constructive dialogue line. And it prepares the ground for a comfortable mediation process. So the main objective of pre-mediation phase is to prepare parties for mediation and to build rapport. And the main deliverable, which is, frankly speaking, happens rarely, is exchanging mediation briefs between parties' lawyers. Unfortunately, it happens rarely in practice. Lawyers with pleasure share the briefs with a mediator or with co-mediators if there are several mediators in the case. But they are quite, in most of the cases, they are quite reluctant to share briefs between them. But if they do, it's really helpful to mediation, to further mediation, because when they share briefs, they get more information about each other, about legal entities, for example, if these are entities. They get more information about each other's position. They may prepare potential questions. They may prepare their answers to potential questions. And again, they can strategize their negotiation line when they have those mediation briefs from the other party. Of course, they can do without mediation brief, but when they have mediation brief shared with each other, it is really helpful and it contributes again to more efficient mediation session. So that's it as for presentation. You are welcome with your questions